considering the financial implications involved and also recognizing the need for structured release of the funds so as to not prejudicially impact state's exchequer, while at the same time balancing the rights of the employees to receive the emoluments due to them, we find it fit to constitute a committee to monitor the implementation of the directions herein above as follows. We have requested Honorable Ms. Justice Indu Malhotra, a former judge of this court. We have also requested Mr. Trilok Singh Chauhan, former Chief Justice of Jharkhand. We have also requested Mr. Gautam Bhaduri, also a judge of Rad Judge of Chhattisgarh. And along with them, the Comptroller and Auditor General of India or a senior most officer in his establishment nominated by him. The import of the committee shall be in consultation with the state authority to determine the total amount to be paid, schedule of payments within which the state shall be bound to follow, periodically verify the release of these amounts. The exercise to determine A and B shall be carried out before 6th of March 2026. The next consequential step, that is the payment of first installment, subject to the determination of the committee, would be paid before 31st of March 2016. The committee shall be accorded all facilities and privileges, including all necessary logistical arrangements. Expenses shall be borne by the appellant state. Insofar as the remuneration is for the committee members is concerned, we leave it to the wisdom of the chairperson. It stands clarified that those employees of the state who have retired in dependency of this litigation shall also be entitled to benefits in accordance with law. Let the appellant state, after payment of first installment, file a status report indicating the determination made by the committee, the schedule adopted, the status of the first payment, list on 15 May for compliance. These pending applications also stands.
Grateful. Very good.
My lords, the employees are extremely grateful.
We'll only say we have rendered justice, that's all. Right or wrong, good or bad, we don't know.
Actually,
chairperson लिखा है ना
grateful.
Thank you,
Very
but for you, we wouldn't have been able to, and my lord's contribution. Largely.
Your lordships have burned the midnight oil. We have only worked around 10 p.m. or 11. Your lordships.
No, you have also burned midnight.
You don't know how much my lord
effort
had to,
We appreciate, my lord. We know.
grateful. Very good. Very good.
Thank you.
Item 1501.
For the reasons recorded herein above, we are of the considered view that the impugned judgment is reasoned and borne out from the material on record, except to the limited extent expressly modified therein. This court does not find any ground to take a different view from that taken by the High Court. Accordingly, the civil appeals are dismissed.
Thank you.
Item 1.
These are the, Royal Lordship against the bench and all. These are that British motor case,
Ah, that-
that 104 is wrong. They said yesterday Lordship adjourned to 17.
We realize that it has to,
Lordship may direct the registry to,
we'll do that. I think the order needs to be corrected.
yes, because it has gone to 17 because Lordship is sitting in the combination.
Order needs to be. Today it is listed, na?
104 it is this.
Ma'am, just wait, just kindly wait.
How many your Lordship then?
Ah,
I just
no,
want
we'll
to
do that.
your Lordship notice.
We'll do that. What we are saying is that the item comes.
Yes, yes, we'll do
You are
that.
here only.
Yes, yes, my lord.
You are one of those
Always a pleasure.
who never leaves the campus of the Supreme Court. Just,
It's always a pleasure, my lord.
your affidavit have you filed?
Yes, madam.
Affidavit.
Item second of February, madam.
Malords, we are,
Very short affidavit I have
we
filed.
give, Malords, we undertake to Malords, provide the requisite undertaking before the jail superintendent.
But,
In terms of the affidavit.
But I fail to understand why a 32 and why a writ petition.
No, Malords, because there are multiple FIRs.
It's okay,
in
you have
different cases.
been granted bail in number of cases.
Malords, otherwise, Malords,
Otherwise, this will become a trend that file a 32 petition and get bail.
No, Malords, in this matter, Malords, because I would have been required because of the medical condition.
No,
there
you have
was an
recently,
urgency.
I was going through this order 212024, you have been granted bail in one case.
That's right, Your Lordship. But in this case,
No,
Malords,
so
I
why
would
to
have been-
bypass that remedy? Then it will become a trend. Everybody will file a writ petition, get a bail. And then if that petition is dismissed, come to this court
Malords, we went into 26 only for this reason.
for bail.
Pardon?
For bail.
Malords, we went, Malords, only for this reason that at 4 different places, I would have been required.
How many FIRs are there against you?
Malords, total Malords cases in which Malords I am in custody, total FIRs are 21, in which 9 I have been acquitted. 12 are the pending cases.
And in 12, how many cases you have?
8 bails I have already got.
So how many are left?
Only Malords 4 matters.
4.
I
So
am
you
in
can,
custody.
if the court has granted you bail in 8 cases, 4 again the court will grant you if there's no material.
Malords, I will be required to, Malords, go to Chittorgarh, Malords, Bali, Jaipur, and Malords, one more place.
Interim bail is for how long? For what period?
Malords, we are requesting a Lordship for 3 months.
3 months medical treatment for 3 months.
Malords, because I am the only, Malords,
One
parent
minute,
available.
one minute. According to you, what is that you say?
Lord, if a lordship will have this affidavit dated 2nd of February, my lord. 2nd of February,
Yes.
very short affidavit on behalf
No,
of the state.
where you have said that he will furnish the details of the hospital where his wife will undergo treatment surgery.
Age
Uh,
3 months.
So what is the period which you have suggested here?
Period, any reasonable period, whatever you have said. On period, I have not said anything.
Maximum surgery will take how much time?
My lords, surgery will not, my lords, it's a post surgery, my lords, recovery will take, my lords, about 2 months.
No, what we'll do is we'll give you 4 weeks time for this. And should there be, depending upon the further requirement, then you move an application.
My lords may have it for 45 days, my lords, for the reason that I am the only parent, my lords. My parents are not alive, my wife's parents are not alive. There is nobody in the family.
We have perused the
Your
affidavit
lordships
filed
may
by the
45
state.
days.
We have perused the affidavit filed by the state. In principle, state has no objection to the grant of interim bail.
It'll be on medical and humanitarian.
In principle,
Yes, ma'am.
for the reason that petitioner's wife has to undergo undergoes surgery,
And there is a 11-year-old child, you know.
and there is none else in the family of the petitioner to attend to her. More so when there is a 11-year-old child born through the wedlock. In these attending facts and circumstances, we allow the application in the following terms. A, the terms and the conditions set out by the terms and the conditions as the state has referred to in para 5 of the affidavit shall be strictly adhered to. The interim bail, the period for interim bail shall be for 45 days from the date of release. The petitioner, during this, we clarify that the protection is granted, that the liberty is granted only for the purposes of the treatment of treatment of the petitioner's wife, who has to undergo surgery on account of her personal ailment. Then after the expiry of 45 days from the date of release, the petitioner shall immediately surrender.
And my lords, conditions we subject to the satisfaction of the jail superintendent.
The condition shall be, no, petitioner shall produce with the concerned magistrate.
Concerned
Magistrate
On.
for
Then my lords, it will require 4 different men. That's why my lords, I was jail superintendent.
Court to fulfill these conditions, my lord.
no conditions conditions of the jail superintendent.
I am going to comply with all the conditions and
That
I will
will-
give my undertaking in terms of the conditions given in
Jail superintendent, and petitioner shall file an undertaking before this court to the effect that he shall comply with the terms and conditions part of the order.
As a lord.
Very good.
Please, sir. Item number 2, I appear for the petitioner. Was in this matter, service is complete on the whole respondent, but as per the office report, no one has entered appearance. Lords, in this matter, I was non-suited on the ground that under the Chhattisgarh Commodification Act, my husband doesn't count as a spouse under the definition of member of the family. So the case against me is that I have created a subtenancy in favor of my husband. But husband is a protected member, my lords. He's the spouse under the definition of member of the family. And on the second count of bona fide requirement, the plaintiff already has 2 other shops in Mahalakshmi market in the same area. And one shop he has already sought eviction against.
Subletting, you may be right, because the definition of 2B includes spouse.
Yes.
But as far as the bona fide requirement is concerned, you see.
It's his choice.
My lords, but I have a certain protection under the Act from eviction.
You take time to, okay. How much
You are
time?
there for the last 21 years.
Please, my
It's
lord.
not your property.
Please, my lords.
Please leave it.
My lords, then in
Please
that
vacate it. No, no,
6 months' time may be granted. I'll evict.
Six-
I'll
six.
close
All
my
right.
business.
Fair enough.
Undertaking.
Please. Grateful. Thank you.
Your good name, please?
Advocate Namrita Chandorkar.
Namrita.
Yes, sir.
We are from my state,
Yes,
my
sir.
undivided state.
Yes, sir.
The lot belongs to the entire country, my lord.
No, but see, all fingers are not equal.
No.
Bias towards.
1 minute. Now, my lord now has to give relief to him.
Why is it Madhya Pradesh?
Unfortunately, my lords, the stage of granting relief today will not come because the state is taking some time to come back with a bit.
No.
So,
Let us see first.
They filed an affidavit.
very good. So my learned friend just told us that, my lords,
There was
they are withdrawing their affidavit.
No.
That's fine, very
Didn't
good.
say that, I'm not
Very well.
going.
Better for us.
Your lordship had asked certain queries on the last date, your lordship, and I had given a affidavit in this regard.
Maybe I'm taking time.
So the number which has come up. Your lordship would have page 3, paragraph 4, where I have just given the list of the query which was raised on that day.
This is which one? Which affidavit?
We
3-2.
have filed,
3-2.
3rd February.
yes,
Yes.
affidavit on the, this is in the 1359, SLP Civil 1359 of 2023.
There are how many vacancies?
Yes, your lordship. Now, if your lordship would have paragraph 6, that the total vacancy of 7129 posts and the category wise detail was given in paragraph 7. Paragraph 6. Then in paragraph 7, it is stated that there was total vacancy of 3546 posts of home guard and the category wise detail is as follows. Then in paragraph 8, it is said that out of the vacancy of 3546, the total vacancy seat filled for all category of home guard is 297. Total women seat filled with home guard is 6. Total women seat unfilled for home guard is 116.
Such hardly 300 people.
Yes. These are the seat, but your lordship, here what the case before you, your lordship, is that they are not having requisite qualification.
No, I was not able to find anywhere. This statement of yours is not in the main judgment. The issue was filling up of the vacancies which could not be which were not filled because of want of home guard candidates to be given to them. That was the issue.
Your lordship, the finding also says that the minimum requisite mark, the cutoff mark was 169.
No.
I'll show that.
That's
The cutoff marks was 169. The marks obtained.
Please show it from the
Please,
judgment.
your lordship. What judgment?
I could not find that line.
Judgment
You're
will follow.
absolutely right. The question is
Counter
about
it.
minimum eligibility, which all of us
No,
clear.
your lordship.
No, it's cut off.
As
Will
per
bear
the
with us.
advertisement
Now that my learned friend is going ahead, allow me to address it. Now, my lords, what had happened was this, and the infirmity in the order.
May I just
My
complete
lords,
your lordship?
no, I am addressing the court.
We followed your cutoff issue.
Okay. But insofar as the minimum eligibility is concerned, every candidate which is before the Supreme Court has minimum eligibility. Those people who do not have, I'm giving it as a caveat, those people who do not have minimum eligibility are not entitled to come in. I'm not claiming for them, first of all. That's the fair submission that I'm making. Second thing is this, that the High Court has messed up, my lords, by confusing the cutoff with the minimum eligibility. Now, cutoff, my lords, is a dynamic concept. If there are 50 seats only, there are 500 people, the top 50 candidates, the lordships are right. Now, my lords, therefore it keeps moving. There were more vacancies. So if the vacancies are increased, the cutoff is bound to fall, point number 1. The vacancies in this case exist. The rules say that if there are vacancies in the home guards and in the women reservation, they will have to be filled up in that year. That is the law. That is what the rules are saying.
No, that is not.
Their own counter affidavit, I'll just want.
Only, no.
So the
He's right. Only in respect of women, the carry forward process will be applied.
Your lordship.
Only for women.
Now,
May I just complete your lordship?
therefore, when it comes, your lordship's right.
horizontal one.
That is, so therefore, because of the application of the law laid down by this honorable court, and we are carrying all of those.
How many candidates are there?
Well, it's
About
320 or something.
Here-
The vacancies are all there.
Can I just?
And there is a stay
One
on
submission,
future,
your
there
lordship.
is a, my learned friend will just bear with me. There is a future stay of future recruitment also by this honorable court. All of us can be adjusted this.
This 2025 recruitment.
Please follow.
May I just complete?
I'm grateful.
My submission, your lordship.
2024.
May I start thereafter?
2024.
2024.
Your lordship would have by
Stayed by
counter
this
in SLP
That's why I
3950.
request my learned friend to just hold his horses for 2 minutes, my lords. I'll just place the facts and after that he can have the consequence. My lords, that process has been stayed. There are vacancies arising from the 2015 advertisement under which we are claiming. This is the affidavit pertaining to that. The last order passed by this honorable court requiring the state to come forward and to give details was only under the advertisement of 2015. So what my learned friend has pointed out in paragraph 7 are the number of vacancies which are available under that advertisement, and they are now being adjusted here. We are candidates who, my lords, have promptly gone to court, have been agitating this by a wrong interpretation of the rules, and from their own counter affidavit, the rules filed by them, we can, my lords, make an attempt to satisfy your lordships, my lords, that the rule position is very clear. Home guard vacancies which are unfilled have to be filled up, number one. Number two, insofar as the women reservation is concerned, the law by this honorable court is very clear. They will not be followed, carried forward. You have to adjust them on this. So we're carrying all of that. So, my lords, today, my lords, once they have shown that there are so many vacancies, without going into anything, my lords, all of us can be adjusted, and I am only asking for an adjustment.
They're your young boy,
May
young.
I just say, lordship?
They are young boys from
Your
the
lordship,
state. Most of them have become
if
over.
if I may be just permitted to make two submissions, your lordship. The first thing, your lordship, as I'm asked by the
Your Lordship, if I may
council for the selection commission, your lordship. Out of these vacancies, your lordship, there were several which have been already filled by the operation of the advertisement of that year only itself, your lordship. So, your lordship, their data also need to be incorporated into
Then
this.
why you give this affidavit?
When I said, my lords, the affidavit, my learned friend just
Then
told
why
me
you
now.
have given this?
After argument, he's coming with this now, my lords.
Your lordship, and the second thing, your lordship, is
Yes.
your lordship have my counter affidavit, which is in the Mahatab case, 3950.
It is not with him, then he's.
We should go down. File a fresh affidavit.
Okay,
My
lord.
lords,
But your
that would
lordship,
be unfair of my learned
let's
friend.
have a.
Initially, he told me that he is taking time because he wants to change the affidavit. Now, my lord, seeing
No,
with the bill not flow.
he might be under the impression that the second new
Yes.
judge is there. So let me take a chance.
No, your lordship. Lordship,
I couldn't have said it with greater clarity. That is all.
No, but see.
The cat
they
is
have-
out of the bag.
They have passed preliminary examination. They have passed written
Yes,
examination.
yes.
They have cleared the interview. They are physically fit.
Document
medically
verification.
Fit.
Yes.
Document verification. You do have vacancies. You do have large number of vacancies. And most of them by now are over.
Correct. That's correct.
If I may only.
No. Either you argue,
No,
we
she's
decided. If you want time to file a better affidavit.
Okay, we'll file it,
There's only one thing I wanted to point.
No, sir.
May I just,
1 minute.
yes, your lordships are not passing in the office today, I know.
1 minute, 1 minute. On the last two hearings, precisely what has fallen from a law, we have said that. That is why we asked for this information. So you better file a better.
I'll do that, your lordship.
Simple as that.
I'll do that.
And let it be a win-win situation for all.
Okay, lordship.
That's all. my lord. The quietest.
Only thing we have to see is intersea seniority between them and them. That's about all. That will
That my lords can decide. That's okay.
Lord, I'm not part of this, but Lord, I have filed an application for it. There is a reason for it.
We-
We are home guards. Our non-selection is under challenge. Your lordship's court, my lord, has issued notice in our SLP.
let us.
Lord, any filling of the post under the directions in this matter.
They have not passed their
Our
means.
interest.
They haven't passed. their
Therefore, I wanted to bring that. to
1
your-
minute.
How many home guards are there?
Lord, we are in all, in our petition about 200 home guards.
So the vacancies are 2,000. 2,000.
There is scope for everyone.
2,000.
It is pending in court number.
Sir, 1 minute. You want us to send it there?
No, I don't say that.
Then
I say we are home guards.
we are saying we'll make a win-win situation for everyone.
Very well, Lord.
Please make sure that you're also accommodated without a judgment from that court. When we are saying that, Don't worry.
But
We'll-
this
we'll-
Vande Bharat Express has got too many coaches. Everybody can be found.
दिखेगा.
One
Expansion to-
clarification must come on record.
Thank you.
I'm only requesting.
Thank you.
So
Thank
that
you.
you can only file an
You have to mention before Honorable the CJ for listing of any man.
No, I'm not mentioning anything, Lordship. I'm on party here, Lordship. In this,
Then it's all right, then we'll consider.
I'm only saying, Lordship, that the affidavit is with respect to only vacancies, not that the horizontal reservation cannot be filled up. That's the
Seeks permission to
The affidavit should be confined to vacancy.
withdraw the present affidavit dated so and so. Present affidavit so and so. Affidavit dated so and so, filed on behalf of so and so, with the further liberty to file a fresh affidavit.
3 weeks, Your Lordship. 3 weeks, Your Lordship.
Containing
No, sir.
better particulars within a period of 1 week.
My lords, I have not even till now heard what those purported better particulars are. My learned friend says better affidavit, but what better affidavit he wants to say is not something that any one of us are aware
Better
of.
affidavit within 1 week, list on dash.
1 week, Your Lordship, will be difficult, Your Lordship. 3 weeks, Your Lordship. 2 weeks.
Data is with them, Manoj. They've gone through everything, they filed an affidavit, it had best a correction.
Thank you.
So we can say. I'm grateful to your Lordship and also to Justice Sharma for putting to my learned friend what I couldn't have said to him. So, that's very good. Deeply obliged.
You were there in that Bihar matter,
Obliged. Yes, sir. That's
so you know the trend.
We've been here enough to see that. So, very grateful. Manoj. Deeply
Grateful, my lord. Much obliged.
Grateful.
May I please? All the affidavits on record, my lords. Lordship's query whether the regulation is applicable, whether Praneet case is applicable, whether are we receiving any amount from UGC, my lords. Because the affidavit says, my lords, up to 2018 we received grants. Thereafter, no grants from UGC by the university. Only with regard to, my lords, women's development, only we have received funds, my lords.
But you have received funds.
No,
Yes, sir.
and your affidavit, with due respect, is a mischievous affidavit. Where is the affidavit? Please give it to me. I'll point it out. It's a mischievous affidavit. मैं बताता हूँ. Please come to your affidavit.
My lords.
Where you have said about that grant.
It's para 3.
पूरा फाइल दे दीजिए ना आपने.
No, this is not the affidavit. एक दूसरा affidavit file किया है. In petitioner का affidavit. This is an application for an empty. कल रात में मैंने देखा था.
Filed on 24.
Filed on?
24/1, my lords.
I've seen it yesterday.
Para 3, my lords.
Come to Parat. So
Well,
what you are saying in this?
It respectfully submitted that the petition university is receiving salary grants from Government of Tamil Nadu. University Grants Commission is not offering any salary for the faculties appointed in the petition universities. UGC schemes 10, 11 and 12 plans are implemented and faculties are appointed in the plan period. At present, 12 plan, Women's Studies Center is alone receiving the grant. Till 2000.
What is this UGC scheme 10, 11 and 12 plans?
These are the plans
What is
for
that?
development of, my lords, travel grant, conference, public grants, appointment of visiting facilities, daycare, adventure sports. That's a heading, my lords, for each and every.
That's a heading. I'll tell you what it is.
My lords.
When a plan is sanctioned, 50 posts, 10 posts, 20 posts comes with the plan.
Please,
And in no university, once the plan is sanctioned by UGC, is discontinued.
my lords.
So this, you are receiving grant for number of teachers under the 10th plan, 11th plan and 12th plan.
My lords.
So just to misguide us, you have simply written UGC schemes are implemented. You have not said that you are receiving financial assistance for paying salary to the teachers under these plans.
No.
So that is why I said it's a mischievous
I'm-
affidavit. You are 100% receiving grant for large number of teachers from the UGC and for Women's Studies Center where teachers are employed.
My lords, I'll.
No.
Distance. I'm so grateful.
Grateful.
I have filed an ID in the matter.
We are not impeding anyone.
Observation to that effect that Your Lordship, we can, on the basis of order, we can.
We are not saying anything, ma'am. So grateful.
Grateful.
Because I'm requesting for a pass over and I'm 5.
Pass over.
Why? That's okay.
Please, my lords. Lord, this is that matter your lordship said twice sent for mediation, my lords, between the husband and wife.
For the past 10 years. Okay. Pass.
Please, my lords.
My lord, only last night I have received the counter affidavit and I need to file the.
Let's see what the matter is.
It is about the additional charge, my lord. And certain deposition has been filed in the counter affidavit. And there are so many contradictions in that. And I need to file.
No, additional charge, see, counter we'll ignore. But additional charge, section 333 allows, so what is there in it?
No, that is, my lord, after
What is
presenting the final argument, after presenting the final argument by both the parties.
Your 482 has not been allowed.
Yes, the police inspector with the deceased.
Yeah, correct.
Has been assaulted.
Yes.
Please, my lords.
My lords, I didn't understand.
Dismiss.
My lords, no. My lords, I have a substantial.
Then argue now. Yeah, that's what we
Kindly pass over the matter. I will bring my file and I will argue the matter.
No problem. No problem.
Sure.
Come immediately because.
But my lord, that the problem is that they have filed particular deposition.
Ignore that.
Sure.
You argue your case, please.
We are making it clear, come immediately, bench is available only for a limited period.
My lords.
And if you don't come by 12 o'clock, we are.
Dismissed.
Dismissed.
Lords, the state was the counter, my lords.
Which case?
Item 7.
No, settlement was there.
Said, my lords, we've filed the SLP praying that there should be a appointment from this court.
Had we not requested for just 1 minute? No, sorry. Yes, argue.
My lords, the state had to file counter, my lords. It's not on record.
My lords, I appear for the state. My lords, it's a concurrent conviction. My lords may hear the matter and call for the records. There are a long list of evidence that has not been filed with the SLP, my lords.
No.
My lords, it's a matter of conviction under 420, my lords. There are over 5,000 members who were made to pay.
1 minute. Now, conviction is there, and suppose if you were to pay the money back.
My lords, it's 420. So, with my lord's permission, it can be. But we'll have to trace the complainants and all the members, my lords.
Lordships refer it to the mediation, my lords. The president will file an affidavit and the association.
You have taken money and you have not given plots. Give their money back.
My lords, I was 22 years, my lords, at that age. 2001 was the date of FIR. I was 22 years, my lords. Today I have come, my lords, only out of all 60,000 members, only 105 complainants are there. Even they have filed civil suits, they are in their respective position. They need something, I am ready to pay. So, my lords,
you're not doing charity. You have to return their money.
My lords, we'll do that. That is the petition. That is why I have filed.
Otherwise, go to jail.
I have filed the petition for that.
No, but will you pay? That's the point.
My lords, I left it to the court, my lords, that somebody should be appointed so that they can put their claims there.
Do one thing.
My
What is the total amount involved?
My lords, they are about 105.
Total amount involved.
My lords, they have to put forth their claim, my lords. We cannot.
We are only asking you, what is the money involved which you have taken from them?
It's the amount.
You deposit in this court.
The president would be the best person to say, my lords, the association's president. We'll do that, my lords. The association president, my lords, if it's referred to mediation, he will come and file appropriate act.
These suits have been filed for what amount is what we are asking.
Suits they have filed for injunction, my lords. It's an injunction suit, my lords. It's at page 24, my lords.
You do one thing, we just pass it over. You ask your clients how much money he is be ready and willing. You see, we are conscious of the fact they have been convicted by the trial court, acquitted by the first separate court, and then again convicted by the High Court.
Yes.
And 2 years is what the High Court has asked you to suffer.
Yes.
Imprisonment. But what is the query put to you is, should you wish to settle, to test your bona fide, deposit money in this court. What is that money which you will deposit here is what we are asking before we even ask them.
My lords, may I submit, my lords? I also have surplus land. If title deeds of the land can also be deposited. Surplus land is there, money.
First,
I'll
to
just
go
find.
out and
I'll
find
do.
out how much of money
I'll.
and how much of land
I'll.
you are ready to.
I'll. I'll.
My lords, as per the charge sheet and even the facts recorded in the trial court, my lords, for the year, because this is almost a 30-year-old incident, and the transactions were in 93 to 95, my lords. My lords, at that time, the charge sheet records an amount of 5,35,000 only, my lords. So, however, my lords, this is as per what is on record, but my learned friend may clarify that. And it's also keeping in mind 30 years have gone by since.
Exactly. See, so 30 years, what would be the rate today is what he has to deposit. Simple.
Yes, my lords.
Go out and immediately just
Give me back matter and.
Grateful, man.
And of course, this will be subject to the other side agreeing. We really don't know whether they want to pursue.
I won't.
But suits are pending, they'll all come to an end.
Please, sir. Yes, 2811, the Honorable Court made an interim order, a speaking interim order. I request to have a look at my lord's order of 2811. Para 3 thereof is a request to consider. If I could place it for your lordship's kind consideration. Honorable Court said, inviting attention to the prayer clause C of the plaint, page so and so, it is argued that the amendments sought to be brought in, as is evident from the application page so and so, para so and so, was not for the purpose of changing the nature or character of the suit. It was mere clarificatory in nature.
Let's see page 71 and 287.
Yes, my lords. Because please have a look at page 84, my lords, want to see, my lords?
Yes.
84, lordship, have a look at. This is a part of the plaint, my lords, the prayer C, 84.
83.
Yes, I'll read from 83. 84 is the prayer C, but I'll read 83 also.
Anyhow, it's all right. That the plaintiff is entitled to get possession of the land.
Yes.
And
the prayer is made, my lords, actually made.
Correct.
No, my lords, then kindly see the application 266. The application is 294, I'm sorry. Where I sought amendment, 294.
What is the amendment? Page 294 that the plaintiff.
Yes, at 295, bottom of 295, just at the top, second line, the plaintiffs are entitled to obtain possession by partition of suits. So only clarificatory in nature. Prayer was already in the suit, my lords. The first appellate court holds in my favor in entirety, but on this ground, kindly see 266, because of which I made the application. 266 is judgment of the first appellate court. 266, para 31 is the request to consider. The appellant plaintiff also, I am for the plaintiff, has a share in the disputed land along with defendant so and so, but he has not asked for any assistance in partition in the claim. Therefore, this court cannot give any assistance to the appellant in getting possession of the land as per his right and share.
What is that the High Court?
But the court says kindly see at 267, 33, on the basis of the above findings, the appeal is partial, the first appellate court. The appeal is partially accepted and the judgment of decree of so and so is set aside. Foreign decree is ordered that the order of so and so is illegal, set aside, not binding on the appellant, etc. So no order for possession. So the High Court in this application.
High Court says it will change the nature.
Yes. That's the only, my lords.
My lords, allow me 2 minutes time and to show you 3 documents. It is my humble submission that they are arguing a settled position. Their amendment application does not clarify. It seeks to change in the nature of the suit.
How?
Yes. Three documents. First, my lords, let's look at their amendment application, page number 294, 295. Page number 294, paragraph number 5, the third last line. My lords, by way of amendment, they want to now argue at the High Court stage that fourth last line from the bottom, my lords, page number 294, that the suit property is ancestral property in which both daughters and the son of deceased Sukya each have 1/3 share. So their first amendment is that this property is not self-acquired, it is ancestral. Just on this point, there are concurrent findings of both the trial court, the first court and the second court. There are concurrent findings. My lords may kindly have page number 149 just on this point. My lords may kindly have 149 of their petition. My lords, page number 149. I'm reading from the last 2 lines of page number 148, my lords. This fact is admitted by the plaintiffs themselves in their cross-examination. Not only this, Mishri Bai, my lords, she was a plaintiff there, she's a petitioner here. Mishri Bai herself has admitted in her cross-examination statement that the disputed land is not the acquired agricultural land of Sukya. That is a father. It is also admitted that the suit property has been purchased by Sukya from his hard-earned money. Her father was a hard-working person. In this situation, it is very clear that Mishri Bai has admitted the fact in a cross-examination.
We must correct you on one point. Okay, are we to look into the evidence which has been laid for considering the application? 1 minute. All that we have to see is the plaint and the application where it changes nature and character. Now kindly come to his plaint, page 78, paragraph 2. Here he says, the heirs of Sukya, father of Kallu includes son so and so. The Amrit died on so and so, before so and so, older Sukya, due to which the heirs of deceased are not defendant so and so. So all that he's praying is that the Sukya's property be partitioned. That's all.
Very well, my lord.
Therefore, he has set up it's not a new.
My lords, on page number 78 itself, the title of the suit was Declaration, Possession and Entry Name in the Revenue Records. The valuation of the suit was as per declaration. It was not for partition. In Madhya Pradesh, my lords, may just allow me 2 minutes.
Are we to look into all this at this point in time, whether the suit is undervalued or not? All that we have to see.
My lords, there are 2 important things that they did not argue for 18 years. The first is partition. There are 2 sisters. How are we to know? My lords, they have simply, by a simpliciter way, said 1/3 share, please include it in our amendment application. Now, my lords, the High Court at this stage cannot go into evidence to see how much share belongs to who. There are 2 sisters. That is something the trial court has to do.
So therefore, the High Court will, all that the High Court has considered, or for that matter, we have to consider whether the application is belated, is necessitated.
But my lord, how can the High Court at the second appeal stage see what is the share of every person in this case? For that, the partition suit has to be filed. 1/3 share is something that they're claiming here in the Supreme Court and in the amendment application before the High Court 18 years after the trial has already begun. Judgment, if I may just cite my lord's judgment. My lord's judgment of 2024, my lords, Dinesh Goyal versus Suman Agrawal. It is my lord's judgment in which my lord has. My lords may kindly see paragraph 11 of my lord's judgment.
Judgment is of the court, not my lord.
My lords, the same bench. Now, my lords, in this case, my lords had very well looked into what is the rule and the settled proposition on amendment, right? And my lords had also cited, my lords, the earlier case, which is Life Insurance Corporation. Now, if the facts of the case are completely changed, in this case, acquired property versus ancestral property and 1/3 share, these are 2 specific allegations, my lord, that requires evidence to be laid.
We again put it to you.
Ji.
Whether the amendment is to be allowed, whether it can be allowed at the stage of second appeal or not, is all that we have to examine. Whether it nature changes, is there any bar that the amendment cannot be allowed at any stage of the? No.
My lords, my only request was this is the Article 136 SLP that they have filed, and there is no reason, no substantive right that is extinguished. The High Court is still going to look into the merits. My lords, let the High Court decide on the merits. If they still have a grievance, their remedies are not exhausted. So why indulge them for procedure at this stage, my lord? That is my only humble submission.
So whether the further evidence is required or not is for the High Court to consider.
But my lords, the High Court cannot be asked to look into, and which is why the High Court rejected it. My lords, we just have page number 3 and petition, my lord.
And counsel to the party we have to consider you that the
My lord, just one last line, my lord. My lords may kindly look at one line of the High Court order, page number 3. Page number 3 of the petition. My lords, the first paragraph, last line. The High Court says specifically, my lords, that the proposed amendment would
invariably change the nature and correct
for partition and separate possession. So I'm saying this requires dismissal at the threshold. That is my humble submission, my lord.
Would you allow us to now?
Yes, very well, very well. My apologies.
Chamberlain allowed him to raise the.
Please, Your Lordship. Immensely obliged, Your Lordship. I'm grateful to Your Lordships. Please.
Yes, my lords. I beg to appear on behalf of the learned ESG, my lords. We filed our rejoinder subsequent to the last order. My lords may post it for arguments any day.
Sorry, say that again.
My lords, I beg to appear on behalf of the learned ESG. Pursuant to your last election, we filed our rejoinder. My lords may post it for arguments on any day.
No, what is there to argue?
My lords, counsel for respondent is appearing to VC.
Please, my lords, I'm there on VC. For some reason, the video is not switching on.
That's okay. We can hear.
Lords, there are serious charges of corruption and sexual harassment in this case. The respondent has been awarded the penalty of compulsory retirement. Soon after, on submission of his pension papers, the pension was reduced to 2/3 of the pension amount by the competent authority, which is the Lieutenant Governor in this case. The competent authority continues to be the same. It's a part of his responsibility and a statutory penalty which has been imposed pursuant to Rule 40.
The Rule 40, does it say that gratuity in pension is to be forfeited?
It allows reduction. It specifically allows reduction of gratuity and pension in cases where compulsory retirement has
My
been
lords, once the disciplinary authority has passed the order.
You were not called
Yes, my
upon.
lords.
You were not called upon. Please.
Which rule says that in case of compulsory retirement, pension and gratuity will be forfeited?
Will be subject to reduction, my lords.
Which rule says it will be forfeited?
Rule 40, my lords.
Where is that?
It's, my lords, it's extracted at page 3 of the impugned order. Lords may allow me to read it. Compulsory retirement pension. A government servant compulsory retirement from service as a penalty may be granted by authority competent to impose such penalty, which is the Lieutenant Governor in this case. Pension or gratuity or both at a rate of not less than 2/3 and not more than full compensation pension or gratuity or both admissible to him on the date of his compulsory retirement.
So that order should contain all this. Kindly read further. From the above, it is.
From the above, it is abundantly clear that reduction in pension or gratuity as contemplated under the said rules is not an automatic consequence of the necessity of compulsory retirement. My lords, this is our argument.
No. There has to be an order. You have.
My lord, that order was this matter. Once the pay and accounts department considered the pension papers, it was reverted back to the Lieutenant General who, upon consideration.
No, he can't pass orders in pieces.
My lords, once the charges have been established.
That it should have been part of the main order only. That keeping in your misconduct, the gravity of charges against you, the competent authority is now reducing your pension all in view of rule.
I quite see that, my lords.
Then the High Court has rightly dismissed it.
There is, my lords, it's our humble submission that seems to be a bit of a technical ground. In that, my lords, once the charge.
Unfortunately, people succeed on technical grounds.
I quite see that, my lords, but once the charges have been established, my lords, what's the nature of the charges? Sexual harassment, corruption.
You could have very well dismissed him for this.
My lord, dismissal was granted, compulsory retirement was granted.
It's not dismissal.
Compulsory retirement, my lords.
Compulsory retirement is not dismissal, madam. You could have dismissed him from service.
What my lord is saying is that if the charges were so serious and severe, in your wisdom, rather than allowing him to step out, you should have thrown him out, which you did not do so. So therefore, as an afterthought, today you cannot say that the gratuity in pension is also to book. Thank you very much. You argued very well. What's your good name?
My lord, Harshita Chaubey.
We appreciate the efforts, the submissions made. While fully appreciating the submissions made.
Yeah, Harshita was fighting with great force.
We find ourselves unable to be persuaded in allowing the presentation.
Grateful, my lord.
Grateful, my lords.
Item 10.
Executive for the petitioner's minutes. As per the office report, the respondents have been served.
No, sorry.
As per the office report, the respondents have been.
What about the office report? We often say that we issue notice for various reasons.
Well, this was a matter where I have filed a fresh suit. But prior to that, I have moved an application under Order 23 Rule 23 Rule 1 for withdrawing my counterclaim. Pursuant to that, I have filed a fresh suit seeking my share in the property. That was rejected by the learned trial court under Order 7.
Finally, come to page 43 and
Any liberty was granted to you.
With all due respect, lords, the order says in terms of the application. Please have an exhibit P3 at page 43 for a while, lords.
Your application is, where is your application?
My application is at
101.
Lords. This application was filed by, this is under Order 7 to 11. Lords, we just have the initial application filed by me for withdrawing the counterclaim.
Where is that?
Lords. Please come to page 40 in exhibit P2. 40. The operative part is at page 42. Lords, for me, married.
While reserving the right to represent the case if a new dispute arises.
Now, please come to page 44, what the learned trial court records. So this is a dispute between the brother and sister. Page 44, if my lords have that. The operative part, I read, on the basis of the application regarding the counterclaim, the application under Order 23 Rule 1 is accepted and accordingly dismissed. Therefore, it was on the basis of the application. In the application, I have specifically stated, I reserved my liberty.
No, just one. Let's read the page 43 together. The case record was perused. From the examination of the case record, it is clear that after submitting the application, defendant Mullabai did not produce any evidence. From the application submitted on behalf of the defendant Mullabai, it is clear that she did not wish to withdraw her counterclaim due to any procedural defect that may cause its failure, but rather because she does not wish to seek any relief from the plaintiff.
Is a plaintiff. For the reason why I said so, my lords may just have my application for a while.
We have seen your
application. The application says that since because there could not be any in future, if any, since the parties were living with each other, both the brother and wife, the brother and the sister, and in order to maintain harmony between the parties.
The only difficulty which is coming in this way is these 4 lines at page 44, top 4 lines. That's the only thing. Because it doesn't say simply that the application is disposed of in terms the application is allowed in terms of the prayers made in the application.
Well, the learned trial court, with all respect, records on the basis of the application. So if I say on the basis of the application, that includes whatever I have stated in the application.
You are the.
I am the sister. I am the sister, and Jhansiram is my brother. My share in the property is 0.49 hectares.
0.49
hectares.
Long pending dispute, small area involved.
Therefore, I was under the impression if the respondent would have been appearing in this matter would have been sent for mediation, but he chose not to appear.
Then what do we do? Thank you very much. Thank you. We're not replying.
Lords, that was all respect, Lords. The application was rejected only when it was.
It's not like that.
Object.
May I please, Your Lordships? Lordships, I've been led by learned senior Rahul Kaushik, sir, but
This is infructuous already.
before my learned friend would say with regard to the infructuousness, let me at least put forth what the issue is, that Lordships.
Let her say.
Lordships, the present SLP is as against the challenge of the order under 227, Your Lordships. The High Court, on 3 occasions which I had presented that this RLTOP is not maintainable, was not considered. As against that only, I've come over here, Your Lordships, before the Supreme Court.
Tenant.
Your Lordships, I am not a tenant is what the dispute is. Therefore, I had filed a suit, which is a proceeding, wherein issues have been freed and PW one has not come into record.
Claiming that you are owner by way of adverse possession.
I bow down, Your Lordships. Lordships, over here. Lordships, but that suit is pending. My humble submission is, Lordships, may I say this?
There's a person who's claiming adverse possession. There's a person who's holding clear title.
No, Your Lordships, that is what. They are not holding title. My submission is not even a single document. Your Lordship may take the rent control proceeding petition. It says that for arrears of rent. But whereas over here, Your Lordships, if assuming they should have filed it, it should be on only 21(2)(a). Your Lordship, last occasion we had circulated the act also, Your Lordships, for your kind perusal. Only under 21(2)(a) they ought to have filed rather